Hi, everyone. So today we are going to be jumping right in to the latest news and updates because there's so much that's been going on that I just want to bring it to your attention just in case this applies to you, okay? Because things change. I'm trying to go live on Instagram and it's just taking me a minute. Um, so things change so rapidly with immigration, especially under this administration, that I want to make sure that you know exactly what's going on and how it can potentially affect you. All right. So before we get started, feel free to ask me questions in the comments. I always want to say that at the beginning, you can ask me questions. And if you're watching this on a replay, please feel free to ask me questions as well. If you're joining me live, feel free to say hi and tell me where you're joining me from. Now, first thing that I want to bring to people's attention is if you have ever filed a green card application and it was denied, right? You filed the green card application, ended up being denied for whatever reason, right? For whatever reason, it ended up being denied, and USCIS did not file a notice of appeal. They did not put you in immigration court. You are just living your life in the US. Guess what? That is going to be changing. That is going to be changing. We are getting reports of people that had their green card applications denied 10 years ago, right? 10 years ago, getting a notice to appear for immigration court. Typically, when your green card application is denied, you want to kind of figure out why it was denied. Maybe you need to appeal. Maybe you need to refile the application. And some people choose to just not touch the application and leave it alone. And if that is you and you chose not to do anything about it and you don't have a pending case, just know you are most likely, you are more likely to get a notice to appear for immigration court now than you were before. Again, this all goes back to the NTA memo. Like I keep talking about the memo because it makes such a difference in people's lives, right? It's making a difference in how USCIS is handling these cases where they deny an application. So based on the NTA memo that USCIS has, officers are now being asked to file a notice to appear when they deny a case. That also means that they can go back, right? They can go back and basically look at cases that were denied previously and see if those people ended up filing another application and they were able to get their green cards or citizenship or whatever it may be, right? They can go back and look at those. And if the person that was denied did not take steps to get a green card or to appeal or whatever else to keep that application alive, they are now slowly but surely filing that notice to appear for those individuals. So really wanted to start off with that because that is a recent development, and we can clearly track it to that NTMO coming out. And again, with this administration, yes, there's the ICE raids and all of that, but they are using the information that they already have available to them to basically go after individuals. So it's not, so every single time you file something with USCIS, you're giving them your information. And typically, it's not supposed to be used for enforcement, but with this administration, they are definitely using it for enforcement purposes. So really important that if you are in that situation where you may have a green card application that was denied in the past and you have not done anything about it, to maybe get a consultation with an immigration attorney, see what options may be available to you. And if you do get that notice to appear, consult a immigration defense attorney to see again, what options are available to you. And I say specifically an immigration defense attorney because I am kind of I'm an immigration defense attorney. So immigration court is not what we do. However, I'm very familiar with immigration court and process and all of that, but we are more of the um, family based, green card, citizenship, dealing with the US Embassy, right? That's more our vibe here. So an immigration defense attorney handles a lot of immigration court specific cases. So if you get that notice to appear, it is putting you in immigration court. So you need an attorney, not just an immigration attorney, but an attorney that does immigration and does immigration court cases, so immigration defense cases. All right. So that is the first bit of news. And the next bit of news that may be a little glimmer of hope for some countries that currently have TPS is that um, the US government is still redesignating or extending TPS for certain countries. So they are not completely doing away with TPS as a concept, as a law, right? They are not doing away with it. So this gives me hope that other countries may also get that redesignation or at least an extension of their TPS so that they're still able to remain in the US and able to renew their work permit. Because if TPS goes away for your country and your work permit is based on that TPS, you are not able to renew your work permit unless you have another basis, right? Another way for USCIS to be able to approve your work permit. So that is really, really important. And again, it's just a little glimmer of hope that this is happening for another country. So we can kind of hope that as long as the countries that have TPS continues, as long as the situation in the country that is designated for TPS continues to be bad, the people in the US that currently have TPS may be able to keep extending it, right? However, redesignation is different from an extension. I just want to make that clear. So redesignation basically means that new people can apply. So if you missed the deadline the last time to apply and you still met all the requirements, you just missed the deadline, you can apply again based on those initial requirements. But if it's not redesignated, but it is just extended, you are basically only able to renew what you already have. So the language that is used when those are done is really, really important. All right. Okay. So I'm just going to take some questions, then we will continue. Hi, Zach. South Carolina. Nice. I have friends that have moved to North Carolina. All right. Hi, Mr. Tusk. Went to my citizenship and it went well. My track shows old ceremony will be scheduled. How long do I wait for that to be scheduled? And what next should I expect to happen? Okay, first off, congratulations. In order for it to say that old ceremony will be scheduled, it means that your naturalization application has been approved. That's the only way the track shows that as the status, okay? So congratulations. You're just waiting to be sworn in and officially become a US citizen. You're not a US citizen yet, but you are very close. So typically they schedule those oath ceremonies typically within 90 days of the approval. So if you do not have the notice telling you where to go, when to go to get that oath done within 90 days, typically best thing to do, reach out to USCIS. Honestly, we have done that in the past where they just forgot to schedule the old ceremony, and we had to reach out to them, do a service request, and they like within a month scheduled the old ceremony because they knew it was on them. It's not like the client did anything wrong. It's just sometimes things, slip through the cracks, but typically 90 days, and then stop banging on USCIS doors. Well, electronically banging on their doors to find out what's going on. And typically, once you do that service request and it's brought to their attention that this still hasn't been scheduled, they will go ahead and get that scheduled. Just know in some places, they save, they do like a big ceremony, or they may rent like a big space for a ceremony. So they would hold applications that they have approved. They will hold them until they have enough applications held so that they will have people to fill the space that they have basically rented for this purpose. So sometimes that's the issue too, because I've had that happen where they're like, we just need enough people, right? We have interviews coming up next week, and we should have enough people, and then we can start sending out those old ceremony um, notices. So it may not even be you at all. Okay. And then once you get the notice, you will need to fill out, there's a page that you need to fill out to basically say nothing has changed since you got since your interview. So because it's been a while since your interview, you need to fill that out the day of your old ceremony. I've had people fill it out and sign it and date it days before the actual old ceremony. No, they want you to fill that out and sign it and date it the day of your old ceremony. Okay, because they want to make sure that as you're walking into that building, that nothing has changed since your interview. And if something has changed, you'll be able to mark it on that. So that's the only thing I want to flag for people when they get that old ceremony notice. Don't go straight ahead and fill it out. Okay, they want to make sure you're filling it out the day of, because something may happen the day before your interview that changes your answer on that piece of paper. So you want to just make sure that you are following the instructions on that. Hi, Ella. Oh, thank you so much. I'm glad. I'm glad the newsletters are helpful. That's why I do them. If you are not on my newsletter and you want to be in it, feel free to send me a message, and we are happy to add you to it. We try to send it out once a week, but depending on how crazy we are with our schedules here, it may not happen. But we do try to send those out once a week to just tell you what recent updates are, right? What's going on with immigration. All right. So your question at Los Angeles, thanks. Are you receiving I-751 approvals? Any news on I-751s? So yes, absolutely. We are receiving I-751 approvals. I think a couple months ago, we received an I-751 approval without an interview. And this was for a waiver case, so based on abuse and cruelty. So we are receiving approvals. They are going to be scheduling a lot of those for interviews since their recent memo on basically all family-based applications being scheduled for interviews. So we are seeing those cases that may in the past be, interview waived, being scheduled for an interview. But are they still being approved? Absolutely. They are being approved. So there's no changes. The only real change is that you may now have a higher chance of having an interview than not having an interview. So you're basically doing away as much as possible with the interview waiver. So, but don't, as far as the requirements, there's no changes. Hi, Francisca, good to see you. Okay. All right, great question, because it's a multi-part question, so I want to make sure um, I read it all together. I would like to understand the reason for the delay in receiving the VAWA receipt. Also, I would appreciate clarification on whether both the VAWA application and receipt process completely free. I would like to confirm whether psychological therapy reports and a psychological evaluation can support a claim for psychological abuse on the VAWA. Please advise if these documents would be helpful. Okay, so I'll take the first part of your question then, since they're two different things. So receipt notices for VAWA applications, U visa applications are taking time. Okay, we are seeing like 100 days from filing, still no receipt. That is completely USCIS. That is not you, that is the normal right now, right? Is what we're seeing with a lot of cases. So it's not really specific to your case. It's not specific to your claim. It's not because you didn't use a lawyer. It's USCIS. Okay, it's USCIS. They are taking a lot of time in issuing those receipts. I believe that has to do with their changes in how they process VAWA cases now, where you have to send it to a specific place, and then that place decides where to send it afterwards, when we all know that VAWA cases are handled by the Vermont Service Center. It should just be sent to the Vermont Service Center. But that is a really big issue that we are seeing as immigration attorneys. I am a member of the American Immigration Lawyers Association, and this is one of the big issues that we are, that the leadership of the organization is trying to bring to USCIS's attention, because it makes such a difference. Because once you have that receipt notice, there's so much more calmness and comfort knowing that your case is filed and is pending. And it also lets you know, okay, USCIS has received it, they have taken it in, versus oh, they send it back to me. So if it's taking them over 100 days in some situations to send that receipt notice, that's 100 days that someone is just sitting there waiting for their case receipt notice. So that is normal. We don't have, USCIS has not given a reason for it. They keep saying that they will try to do better, but we have not received any active reason for them. Okay. Whether it would be helpful to have a psychological evaluation or therapy reports for your VAWA case. If your VAWA case is mostly based on psychological abuse and not on physical abuse, you would want to include evidence of that. And sometimes if the person is already undergoing therapy, their therapist can write a report. If they're not already undergoing therapy, they may choose to do psychological evaluations. There are psychologists that their practice is meeting with people and doing these psychological evaluations, whether it's for immigration or for family court or whatever it may be. But they do these evaluations for people to basically see what their whole thing is, right? So you want to just be sure that it's helpful, the person is licensed. That's really the key with having psychological evaluations or psychological therapy reports, making sure that the person is licensed and is qualified to give the opinions or recommendations or to issue the reports that they're trying to issue that you will then use for your case. You want to make sure that you have those, that you can basically ask them for that to make sure that they have the qualifications. As far as the fees for VAWA, it depends on the person's situation, right? So if you would like to have a quote, we recommend scheduling a strategy session because that will just help me know more about your situation to then tell you how much our fee is for that specific case. Okay, so yeah. Hi Malik, thanks for joining. All right. So I heard from a lawyer saying USCIS denying 601, 601A, and 212 without notice of intent to deny. Is that true? Yes. So there are certain cases where USCIS is required to send a notice of intent to deny, and there's cases where they are not. So it depends on the actual law. So not every single case requires a notice of intent to deny. An I-130 is a case that requires a notice of intent to deny. An N-400, so the naturalization application, requires a notice of intent to deny, or at least a continuance, right? Where they ask you for specific documents. So it may not say a notice of intent to deny, but it may say like a continuance. But they have to send you some notice asking you for additional documents or whatever else. But a 601 waiver, a 601A waiver, a 212 waiver does not, the law itself may not specifically require USCIS to issue a notice of intent to deny. USCIS may have a policy of sending those out to, make sure that they give the person the opportunity to give them as much information as possible. However, it may not be strictly required by law. So those are two separate things. USCIS policy can change, right? How they choose to handle things can change. However, if it's in the INA that they have to issue this notice of intent to deny, that's a completely separate thing. And I want to make that as clear as possible, right? The INA is the law. The USCIS policy manual is how they apply the law. Okay, so it's not always like one-to-one where whatever the law says is how it's applied to every single case. It may just be that that specific case, right, that one case requires that thing, not that all the cases require it. So I hope that answers your question. All right. So next. Late is that okay. So one, it's not against the law if the INA does not require it, which is why they're able to do it. So for a green card application, an I-485, there's no requirement for them to send a notice of intent to deny. So they can deny it without a notice of intent to deny. But an I-130, if an I-130 is denied without some form of notice, then maybe you will have a legal case, but for the waivers, most likely not. Okay. What are the consequences of checking yes to the box on N-400 application, asking if you were deported, but it was voluntary departure, proof of voluntary departure provided at interview? Well, voluntary departure is not a deportation. So if that is the situation, it wouldn't really make much of a difference, right? Because you provided the documentation. I think the reverse would be it's a bad thing. So it's okay to not understand what the term means and think it applies to you and your situation and explain it to the officer. However, if you said no to that and it was actually not a voluntary departure and it was an actual deportation, that's where the officer would have an issue. However, typically if you check yes that you were deported, the officer wants to know, when were you deported and how did you come back into the US? Because after a deportation, you would need to then have a visa to come back to the US or be paroled back into the US in order to have gotten your green card and then have applied for citizenship. So that's where the officer will have those questions of, if you were deported, how did you come back into the US? Just make sure that you follow the right procedure and that you properly were admitted as a permanent resident. Okay. So that's why they are asking that question, is if you were deported, how did you come back in, and did you follow the proper procedure? Okay. But with a voluntary departure, it's not technically a deportation. However, as long as you provide the proof of voluntary departure and that you actually did depart, the officers are usually knowledgeable enough to know that that is not a problem for citizenship. Again, depending on your how you came back, right? That's the key there. How did you come back? Mhm. Hi, Carl. Thanks for joining. Um, what happens if you have an I-751 pending for 4 years and now you filed waiver based on divorce? USA will still process your application. You'll be scheduled for an interview, most likely, and you'll need to explain to the officer, you know, still present evidence of your relationship, and then the divorce is the waiver. It will be the basis of the waiver. You do want to inform USCIS, proactively inform USCIS of the divorce. So typically we send in the divorce certificate and ask for the case to be updated to a waiver case. And then at the interview, the officer will then ask the questions that are needed in order to approve or make a decision on the case. So basically, and this is a mistake that people make, is that once they have that I-751 pending, they think they need to file a new I-751. You do not file a new one. You just update USCIS on the current status of your relationship. So you file jointly. Now you're divorced. Here's the divorce certificate. Please update my case. So, but if you send in a new one, then it may get a little confusing for an officer if they are not sure what is actually going on and why they have two I-751s. Okay, so be very careful with that. All right. So let's see. Hi, Barhane. Good to see you. Okay. All right. So if an I-485 gets denied and referred to court, can you still get denied? Yes. So if the green card application was denied by USCIS and then USCIS sends a notice of intent to deny, sorry, I still have a noise in my brain. And USCIS sends a notice to appear for immigration court, you can still file an I-485 with the immigration judge, and then the judge will make the decision. If it's approved, then you have your permanent residency. It's harder in court because now you have a government attorney that their job is to make sure that the judge does not approve your green card application in court. So it becomes a whole other issue. Before, we were able to like get cases terminated and file it with court with USCIS again, but you need to still qualify for the green card once you're referred to court. Okay, that's really important, is to make sure that you still qualify for the green card and that you still meet the requirements, whatever that is. So if it's a marriage-based green card application, was the I-130 approved? If the I-130 was not approved, then there's really no green card application, right? Because the I-130 has to be approved for a marriage-based case before USCIS can even consider the green card application. So if the I-130 was denied by USCIS, the green card application will automatically be denied as well, because you no longer have an I-130 to base it on. Okay, so if you're put in immigration court after the denial, you will still need an approved I-130 in order to file the green card application with the court. So, um, so it's a whole thing. Okay. Okay. Thanks for clarification. If the Okay, so if I-485 gets denied and referred to court, can you still get detained? It depends. So ICE basically has jurisdiction to make those decisions. If they feel that the person should be detained, yes, they can still detain the person um, while they're going through their immigration court process. It depends on the reasoning, though, right? That really makes a huge difference, the reasoning. So, one, it's going to depend on if the person already has like a um, final order of deportation, they're most likely going to get detained. If they have a criminal case that makes them inadmissible or deportable, actually, that makes them deportable, they're most likely going to get detained. They're more likely to be detained than someone that's just in immigration court with no final order of removal and no criminal history, right? However, if you're around someone that does have a criminal history or final order of deportation and ICE comes, you can't get swept up in that raid without having any of those things. Right? What kind of questions at the interview? Great question. What kind of questions at the interview I-751 petition waiver based on divorce? Questions about your relationship, right? The office already knows you're divorced. So that's the waiver. Your spouse doesn't have to be here for the interview. You're divorced. We see the divorce certificate. Great. The waiver part is over. Now let's talk about the marriage. So it's questions about the marriage, questions about your former spouse, how you met, their parents' names, their names, like every single thing you will expect from an initial marriage-based interview, except for this one. Okay. Your life together for that 2 years. Like, when did you two separate? Why did you two separate? What was the reason for the divorce? Like, who filed for divorce? Things like that. Expect the officer to go into detail about those things. Like, did you ever take trips together? Did you have documentation of your life together? Right? What kind of car do they drive? Those kind of questions. Expect that, because that's going to be the bulk of your interview. It's going to be your life together, right? How well do you know your spouse? And the officer is only going to ask you, is most likely only going to ask you questions they either already have an answer to, because you may have a previous interview and they're comparing the answers to your current one, right? Or they already know that you traveled. They can sometimes pull your travel records. I have had an officer, no joke, during the interview, ask my client, okay, did you take any trips since you got your green card? She says, yes, I went to blah, blah, blah on this date at this time. Great. And then, oh, who went with you? She's like, oh, no one, just me. No one went with me. It was just me. Guess what? At the end, the case was approved. And before we left, the officer's like, oh, I saw you at the airport, because the officer already pulled the records of her travel history to see. That's what I want people to understand. USCIS is the government. They have access to things that you do not have access to, things that I do not have access to. So they were able, from her travel history, because when you're a permanent resident and you're coming in and out of the US, every time you come in and out, there is a record of it, right? There is a record of it. There's your travel history that USCIS can always pull. And they were able to pull that record, pull video from the date and time, and were able to see that my client was truly by herself, as she stated. And she knew that, the officer knew that before she asked the question. So when I tell you that they are now going to ask you some, random question that they may not already have an answer to, they're not going to. They're not going to. So it's really important that You know that going into it, especially when it's an I-751, where it's not like, they're not typically comparing your answers because it's based on a waiver, right? If it's based on a divorce waiver or an abuse waiver, the other party is not there. So they're basing it just on your answers. So they're going to things that they can ask you about to make sure that you are telling them the truth and the whole truth. Okay? So just know that. When people ask me, oh, how would they know? How would they know that I traveled with my ex? How would they know that I didn't travel with my spouse? They know. Trust me, they know. They can get that information. All right. Bahrain. Submitted my wife's I-130 and I-45. She came through the humanitarian parole from Nicaragua. Her year green card expires in June 2025. Can she continue working after green card expires in June? Okay. I think you mean the work permit or the parole that expires in 2 years, not the green card. Just file the green card, right? So so typically, no, she cannot really work once that card expires. What you can do is file a work permit based on the green card application, right? So typically when we file a green card application in my office, if it's for an adult, we are also encouraging them to include a work permit application, because that means you can get your work permit and be able to work while the card application is pending. Okay. And then depending on the situation, green card applications take time, but work permit applications take about 6 to 8 months, but they can be sped up if you have a job offer, if you are, at risk of losing your job because you don't have your work permit. You can request an expedite. Okay. You can request an expedite with documentation from your employer showing that we're going to fire you if you don't give us a renewed work permit, right? Or we're not going to hire you because you don't have a work permit. In those situations, USCIS is more likely to expedite the work permit, not the green card application, but they can expedite the work permit because you need it in order to work, because you have a tangible job or a job offer that you can basically do, but for the fact that you don't have this document. So that would be the recommendation, is to just apply for the work permit on the green card application, because the more you can go to your interview and be like, nope, I've never worked without authorizations. I came in with my parole because I had my work permit under the parole, and now I have my work permit under the green card application. It just looks good, right? It's not going to be a problem if you work without authorization, as long as your spouse is a U.S. citizen, right? Their petitioner is a U.S. citizen and is your spouse. It's not going to be a problem. But for comfort, we typically recommend including that work permit. All right. So I don't see any other questions. Let me see. Okay. So if you have questions, please feel free to ask. Want to make sure that we have everything. And Malik, yes, feel free to contact the office and we can certainly help with that. All right. So for those that are just joining me and wondering what is the latest in US immigration, because I have been talking for a while, I want to make sure that I do cover that. So first thing to know is that if you have a green card application that is denied or was denied in the past, and when I say past, I mean past. If you have ever had a green card application denied, you may be in a situation where that application can end up landing you in immigration court proceedings, because they are now issuing notice to appear for people that were denied in the past. So not even based on a current application, or that the person got a criminal history after that denial or anything of that sort. Nope, that because the person was denied, they are issuing those notice to appear. They're going backwards to do that. So just know that is happening. We have a little hope when it comes to TPS because the Trump administration is open to extending TPS for certain countries, depending on the status of the country itself. So hopefully we can see the TPS for Haiti renewed, because the country has not gotten better, at least according to US reports. They have not gotten better. So hopefully that TPS gets extended. So just a little bit of hope in the general, immigration hellscape that we live in right now. All right, next question. Okay. What does it mean, no fault divorce, as you filed waiver based on divorce? So, a no fault divorce in most states means that you don't need to give a reason for why you want to file a divorce. Like, you're not saying, it's kind of like saying irreconcilable differences. Like, we just want to be married to each other anymore. That's a no fault divorce. Okay. It's just, I don't want to be married to you. You don't want to be married to me. Let's go and get this divorce done. That's a no fault divorce, right? It can't just be, some states, it can just be one person saying, I don't want to be married to you anymore. You didn't do anything, right? I'm not going to argue that you did anything that the law says I can get a divorce for. I just don't want to be married to you anymore. That's a no fault divorce. There's, states, each state has their own fault divorces. But most people, unless they have to prove something under the law in order to get alimony or things like that, will not do anything other than a no fault divorce, right? So that is completely normal to do for a waiver. So the waiver is not saying that there's anything your spouse did wrong. A divorce waiver is literally just saying the only reason I am not filing the I-751 jointly with my spouse is because we are divorced. That's all it's saying. It's not saying that your spouse did something wrong. It's not saying anything. It's just saying the only reason that I'm filing this by myself and not jointly with my spouse is because we are no longer married to each other. And here's my divorce certificate to show that we are no longer married to each other. You can ask me questions about our relationship. I can send you documents about our relationship to prove that it was real, but we are no longer married together. So they're not going to show up to the interview, and they may not, they're not going to sign the form, and they're not going to show up to the interview. It's just going to be me. That's all that is, okay? So having a no fault divorce for I-751 based on divorce waiver has no effect, right? Because all you have to show is the divorce certificate. You don't have to show the reason for the divorce, right? I hope that helps. Okay. The future apparel, please, what are the current times for EADs, travel documents, green cards? Ooh, yeah, that is a lot. So EADs, like I said, 6 to 8 months. That's still the normal processing time for those, at least in practice, right? So the USCIS website is may give you a different timeline than what we see in practice. I always tell people to go with the USCIS website because their processing can change at any time. So in practice, we're seeing 6 to 8 months, sometimes less than 6 months, even without asking for an expedite. But in some cases, we're almost always asking for that expedite when there's a job offer for the work permits. For travel documents, you're looking at almost a year in some situations. Again, unless you have an expedite request, pending, like there's an emergency reason that you really, really need to travel, and they may expedite that travel document. Green card applications depends on your jurisdiction, right? My local jurisdiction in Massachusetts, we're seeing about a year to a year and a half, sometimes less. Okay, but a year and a half is pretty normal for green card applications in Massachusetts. The website is going to say what the website says. Okay. The website is going to say what the website says. However, I'm talking about in practice. And when you're looking at the USCIS website for green card applications, please, please do not look at the I-130. Okay, do not look at the I-130. If you are filing an I-485 with your I-130, the processing time that you need to look at is the processing time for the I-485. Okay, not the I-130, the I-485. So you need to go and look at the specific, find out what's your local USCIS field office, because you need to know that, so that when you go to look at the processing time for the I-485, you can select that specific field office from the drop-down menu, and it will give you a better scope, right, time frame for when you can expect an I-485 interview or movement in your case. All right, but if you are filing an I-130 and an I-485 and you're looking at the processing time for the I-130, it is going to feel like you are waiting for an eternity, right? That you have to wait for an eternity, because they are not taking into account that you also have this green card application pending. Okay, an I-130 on its own does not typically get an interview. It's typically done on the service center level. And it's going to vary dependent on if the person is married to a US citizen or not. There's a lot of factors that go into it. So they're going to give you their broadest, like their longest timeline for the I-30, but you need to look at the I-485 for your local field office. And if you do not know your local field office, go on the USCIS website. They should have like a locator for field offices. You put in your zip code, it will tell you where your local field office is. So that way you can then go on the on the processing time site and put that specific field office. Okay. All right. Malik. All right. Are some cases better in court than USCIS? There's, in my opinion, no. No. I try to get my clients out of court as much as possible, unless they qualify for cancellation of removal, which you can only do when you are in immigration court proceedings, right? If they do not qualify for cancellation of removal, we typically try to get them out of immigration court as much as possible. Listen, with USCIS, you go to your, you file your case, you have an interview in most situations, and you fight for your case, right? There's no threat of deportation while you're fighting with USCIS, right? With court, right? With court, every single thing is being fought over, because there's a government attorney that their job is to make sure that the judge doesn't approve your case. Yes, with USCIS, you're kind of fighting the officer, right? The officer is going to have opinions, just like an immigration judge is going to have opinions, right? And then make a decision. But with court, you have an active opponent in court versus USCIS. Okay. In my opinion, some USCIS officers take an active opponent position for cases. However, there's not really much you can do about those things. There are cases where the only people that can handle it is USCIS. So an I-130 is USCIS only. So if USCIS denies your I-130, you're not going to go to immigration court and have an I-130 approved by the judge. Doesn't happen. Okay. You would need to file a new application or appeal your the USCIS decision on your previous application in order to hopefully get a different result. We have done that for some clients where they were previously denied and then put in immigration court. We were able to reverse those decisions or at least refile their I-130 and get them approved the second time. It just, I do not, in most situations, I get my case out of immigration court. Because if you get the wrong judge, that's the other thing. If you get the wrong judge or a judge that does what they want, you may end up being denied. Okay? You may end up being denied and you have a deportation order. So there's no time that I'm like, yeah, get yourself in immigration court. Like, no, especially this administration and the shenanigans that they're doing in court. Absolutely not. Absolutely not. So which ones? None of them. Go with USCIS. Let immigration court be the last resort. Okay? Let it be, okay, I didn't win my green card with, with USCIS. I'm going to refile it with the court if I'm put in immigration court, right? But just know there's some cases that the judge does not get to decide, that USCIS is the one and only government agency with jurisdiction over that case. So just know that. Yes. So Carl, irretrievable breakdown. Yes, that is a no-fault divorce. It's just basically saying the marriage is over. We don't foresee us ever getting back together. We don't foresee any reconciliation. So we just want to be done. So that's the no-fault divorce. All right. Great questions. Please keep asking them because, it's really helpful for people watching or that will watch this later. Some of the questions you ask sometimes leads me off into a tangent to bring up something else. So please do ask your questions. I truly appreciate that. All right. And if you're still with me and you get value out of this video, please don't forget to like, share, and subscribe if you have not already subscribed. If you're watching in a place that you can subscribe, I know some places you can't, but if you're watching in a place where you can subscribe, please feel free to subscribe. All right. So don't see any other questions, and we are almost at the 1 hour mark. So let me know if you have any questions. If I see any questions, we're gonna get off today. So I do want to let you know, if you want to schedule a strategy session with me, I'm sure you're at the bottom of your screen, but you can do that by going to my website, lilylegal.com, and clicking on contact us. You don't have to call the office to schedule that strategy session. You'll get to see my schedule right on the website, and you can pick the date and time that works best for you for us to chat about your case, okay? And typically, if you need to send us anything for your meeting, we'll be following up with you regardless. But if you do need to send something, you can to our email. But we do have that linked on our website, so you don't even have to bother calling us. You can just schedule it. And sometimes people ask us like a specific question. Right? When people ask us specific questions when they're scheduling the strategy session, sometimes we're able to just answer that specific question. So that's why I say that's the best way to do it, because that way you can actually put in your exact question that you have for us. And sometimes we're able to just answer your question through that as well. So, oh, thank you, Carl. Truly appreciate it. So if there are no more questions, thank y'all so much for joining me as always. And I will be seeing y'all next week. I believe so. I usually take one Friday off, but I believe I'll be here next week, Friday, and we can talk way more about immigration and bring your questions. That is literally why I do these lives, because there's so much going on, and I want to provide you guys a place where you can come on Fridays and ask questions, especially with all the changes that are happening. So thank you all so much for watching. If you're watching on the replay, thank you as well. And I will see you next time. Oh, like, because that question just came in and I want to make sure I answer it before I get off. No, that's not true. So if USCIS denies your application, you typically can reapply if you still qualify. It may be harder to get it approved the second time around, but then they are accepting those applications. I have cases that we've had to refile after they were denied, and they came to us after the denial, and we were able to refile it without a problem. So that is not the truth, okay? So again, you can refile if you still qualify for that thing that was denied. All right. Okay. We're going to end there today. Thank you all so much, and I'll see you next week.